All right, everybody, welcome to the Creative Finance Collective. This is our opportunity to get together and discuss all things creative finance. We'll be taking for the hour or until you cease having questions. We'll be taking creative finance questions from the audience. So if you have questions, post them to the chat. We'll be reviewing the chat and we'll take your questions as they go. We got a few people here. Myself, Sean St. Clair. Looks like we got Alan Seschker in Texas. And Scott Horne is making attempts.
Well, I'm
There he
here.
is. Oh, okay.
Just trying to get it on my computer, not on the phone.
All right. Well, we'll let you work that out. Alan, how you been?
Real good, real good. How about y'all?
We're doing all right. What's the latest in your neck of the woods?
Well, you got out of jail.
You know, status quo. And did he say I'm not in jail? That's good.
That's always a successful start to the week.
It is. It is. We're still working hard on agent outreach, getting what I call the consumer mortgage wrap out there and going, and that's getting some movement there, and then just trying to figure out what's going on with the due on sale clause issue. We're still having instances of those problems, so getting our arms around that.
Are you still seeing problems with that post kind of the solution you discussed with doing land trust?
Yeah, so we're not necessarily closing in the trust, but we're ready to move them over to a trust if we have a problem. The consumer, the end user seller, end user buyer, we're pretty much well more than half the time we're putting those in a trust at the outset.
Okay. But you're not. It sounds like you're still having more problems. Are the problems you're seeing on due on sale clause with transactions that were done, old transactions that were done kind of the old way, or are you seeing the problem arise even with some of the corrective ways you're thinking of handling it?
So they're not older transactions. They're transactions that are occurring recently, last couple months or so. I still think that it's more often than not related to the insurance getting put in place incorrectly.
Okay.
We did have one. We had one where the insurance renewed, so I guess it was about a year old, and they went with a different insurance agent and didn't get in place correctly, and then we had the problem.
Scott, are you seeing a rise in due on sale clause problems at all? Scott, we can't hear you.
Uh-oh.
We can see you and you look glorious, but we don't. While he works on that. If you're just now joining us, we're taking questions throughout the hour or until we stop receiving questions, or until we get sick of each other. So if you have questions, make sure to post them. We'll answer anything related to creative finance. Scott, are we coming through?
Any better?
Oh, yeah, I can hear you now.
Okay. Why these settings changed, I don't know. Technology, right? So not seeing anything really different. Had one from a month ago that, I can't tell you if it was the wholesalers mess up, if it was the investors mess up, someone called the mortgage company. They don't know how to ask the right things. They want to send them all this paperwork, and instead of just simply going online or using the seller to call in and get a reinstatement, they call up, they order payoffs, they do this, they send in all this paperwork, and now the mortgage company's going, what's going on? Why are we getting all of this junk? And I think this raises red flags for them sometimes. And I just see that being problematic because everybody and their brother wants to be a TC, and it's the blind leading the blind again.
We talked a little bit about this last week. Alan, I don't know if you were here for this. Have you seen it increased problems with or files that have had problems because of transaction coordinators?
Yeah, we are. They're not familiar with the transaction, and they're trying to run it like a conventional transaction, and then I guess learn along the way, and they're not learning quick enough and being clunky.
All right. Well, we have a question. Post this to all of you, give you a chance to see what you think. Which lenders have the most restrictive due on sale clauses? Are there particular types of due on sale clauses that are more restrictive or less restrictive, or are they pretty much all the same? I know they all try to probably create it as broad as they can.
Well, I'll just comment on this. I think due on sale is due on sale. You know, well, if you want to talk about, have I seen some where, you know, not only is it the conveyance of the mortgage, the conveyance of a beneficial interest, executory contract. A while back, I saw one that even had a lease in excess of 3 years, but that's been a long time since I've seen that one. I think the issue is not a restrictive due on sale, because due on sale is due on sale. I think the issue is which lender is more problematic. And it's not which lender, I think it's which classification of lender. Because, you know, if you go to a credit union, they are typically portfolio lenders, and they're small. And they're going to have people who are going to have their fingers in the pie on every single deal, I think. If you have a very small mortgage company, which may actually act as a servicer for their lenders, here in the DFW area, Colonial Mortgage is one of those. You know, I've run across that. But you get into your large loan servicers, the Mr. Coopers of the world, et al., I think you're fine. So whenever, I was going to say this, whenever I see a credit union out there, I'm suggesting to the investor buyer to consider conveying the property into a land trust, getting proper insurance with the land trust, hoping that may ward off anything with that lender.
So I'm going to disagree with you a little bit, Scott, because I don't think it's all just due on sale. You know, it's a clause that will be in the deed of trust, and it's going to define what an alienation or a transfer of the property is. And they're not all the same. So Fannie Mae Freddie Mac's deed of trust form is going to have a due on sale, and I find it to be the most restrictive because it even prohibits an escrow agreement by which the borrower will convey title at a later date. Well, what's a purchase contract? It's an escrow agreement by which the borrower will be conveying title at a later date. So every time the borrower enters into a purchase contract, technically it triggers the Fannie Mae Freddie Mac due on sale clause. Now, FHA has a much or a less broad due on sale. And if you look at the FHA due on sale, it doesn't prohibit leases or options. And so under an FHA, while, you know, they're real aggressive about, you know, the actual conveyance of title, if you look at their due on sale clause, it doesn't prohibit the leasing of the property or an option. Now, there are other covenants that the seller makes as far as residing in the property for a year and all that kind of stuff. But the actual alienation clause in that deed of trust is not that broad, and you can get away with it. Now in Texas, you have other issues, right, with that. But here in Arizona, we can get away with a lease with an option to purchase. It doesn't even restrict it. Like, it doesn't even reference lease or option.
Well, Sean, I agree with you that if we're talking about options and things of that nature, even a contract for deed that may or may not be recorded, if it's not recorded, of course, the question becomes, how is the lender ever going to discover either an option or things of that nature that are unrecorded, other than the fact that they might be getting a check from somebody different? So that's about it. But on the surface, yeah, I agree with you. You can get really honed in on things like that. But for just the true due on sale, where an investor is buying a home subject to the existing debt and is taking legal title to the property, that's going to effectuate it, I think, regardless.
Right. No, I agree. There's no due on sale clause out there that's not, that particular way of conveying or taking an interest in the property is not going to trigger it. But, you know, when you look at, I mean, the question was the most restrictive due on sale clause. And I think the Fannie Mae Freddie Mac. I mean, they list everything from options to contracts for deed. You know, they specifically listed all, including purchase contracts. Like you can't even enter into a purchase contract without triggering the Fannie Mae Freddie Mac due on sale. Now it's an option for them to proceed. So they don't really care about a purchase contract, but technically it would trigger it. So, and then you're right, on credit unions and community banks, they're going to have different due on sale clauses. Some of them are going to try to prohibit leases, things like that, which Horne St. Germain, you can't prohibit anything less than 3 years as long as it doesn't have an option connected to it. So yeah, I agree. But if you want to be creative and try to figure out maybe how you can acquire even a possessory interest in the property with the right to purchase later on, you're going to want to look at those due on sale clauses, because a few of them you can maneuver that without triggering it. You know, at least here in Arizona and Texas, you may not have that.
Do y'all remember that little vehicle? Gosh, this came out 15 years ago or more, and it was called a PAC trust. Are y'all familiar with that at all?
Not me, no.
I want to say the guru was some guy by the name of Brown. He was out of California pushing that out. And, you know, I hear some investors today mention things like that, which is where you create a trust and the seller and the investor and even the back-end buyer are all three beneficiaries under the trust. And they all think that this is a way to get around due on sale and whatnot. And I go, maybe, but who in the heck is going to take the time to explain that to a home buyer who's putting down $30,000 or $40,000 in a down payment that you don't own the entire property, you only own a percentage, and other people have potential interest in your property and things of that nature. You know, you want them to think a little bit further down the road as to, you know, what can happen and who is going to take the time to explain that to the borrower, what's going on. Then once you start explaining that, of course, the question arises, are they practicing law without a license?
Interesting. Alan, you, I think we're going to jump in too when we first started. What's been your experience? Are there particular lenders that are less restrictive, or that you've noticed?
No, I was gonna take the question the way that y'all actually already addressed. I think the credit unions, small banks are going to be more strict on their enforcement of it, and then I'll call out Home Loan Serve again. Because we had another one called due with that servicer. Don't know what's going on there. I still think it's clumsiness. I don't think it's necessarily them watching. I think it's them being triggered to the situation via some type of error or failure in process by the investors.
All right. If you're just now joining us, this is the Creative Finance Collective, and we're taking questions as we get them relating to creative finance. So if you have them, post them in the chat. We'd love to answer those. Also, you'll notice at the top corner, there is a barcode that takes you to our YouTube INREM podcast page, which is really the best place to interact and engage with our content. With that, we have another question, guys. Thinking a little bit of you, Scott, on this, because I know you like to talk about liens. Are there any types of liens that you would never take subject to? So put yourself in the shoes of I guess an investor and a lawyer. Is there a lien that just scares the bejesus out of you, and you wouldn't touch it with a 10-foot pole?
You know, the first answer is no. The next answer is maybe. Because it depends on, what the lien is and things of that nature. You can cure so many liens, number one. And here in Texas, there are ways to remove some of these things. But, if an investor is going to buy a home, let's say it has a child support lien on it, and you're buying it from the seller. Well, before they buy that home, I want that child support lien removed. And so long as the seller, the bad actor involved, is not getting any money, or whatever money they are getting goes to the Attorney General's office here in Texas, okay, they will remove that lien for you. Restitution liens, and I don't see a lot of those. I've only seen that maybe actually 1 or 2 times ever. But the feds and the state will remove those so long as I know that the bad actor or someone closely related is not benefiting from the sale of the property per se. Would I buy a property subject, and again, here in Texas, since, probably 98% of the houses that are transacted are homesteads, if there's a judgment lien out there, we can remove that as well. So what does that leave? That leaves, standard mortgages, no problem. A reverse mortgage. I'm not worried about taking a property subject to reverse mortgage. It's just going into it with the realization you very well may have to pay that off within 12 months or less, and you better be prepared to do that in some format. And if you can do it, great, get it done. But is it okay to do? Sure. And then you come up to the IRS lien. And, my first comment with the IRS liens is it's the federal government. They didn't hire 80,000 new agents to go out and hunt things down. And they're just lazy is the bottom line. And I'll share ideas with you guys where I've done deals where I bought a home sub to a $1.7 million IRS lien. Now, the great majority of that fell off fairly quickly. And you go, well, would the IRS ever renew and extend? And I'll just say I've never seen that happen before. So, it's going to depend if there's an IRS lien on a property. How much money am I going to be out of pocket and am I willing to risk if the IRS was to call that loan due? And how big is that IRS lien? And that's where the gamble comes in. And, if you like Vegas, great, roll the dice. If you don't, okay, don't do the deal and walk away. But I will tell you that to answer the question direct, I don't have any direct lien issue that would trouble me too much. It's just you better understand how to navigate it, what the time frames are, and be prepared to deal with it. Because if you elect to sell that property using a wraparound mortgage as opposed to a rental, one, you got to disclose it to your back-end buyer, and two, if that back-end buyer ever elects to sell or refinance, you're getting stuck with that thing and paying it off.
Yeah, and I think answering or going a little bit further or just restating some of what you said is it's not as much the type of lien, it's the due diligence going in to know, what the lien is, how long's the lien been there, what is the statute of limitations that might apply, is this something that could be negotiated for pennies on the dollar? All those factors apply in their own, factual and unique ways, depending on the type of lien.
Yeah. Let me just bring up one more, coming to mind here would be, your municipal liens of some type. Whether, property tax liens, they don't go away and you're not negotiating them down. Municipal liens from things like red tags, from civil actions, demolition liens, and those kind of items. You have to understand that the great majority of the time you're going to pay those, or the majority of those. You can negotiate them, but you better be prepared to go negotiate it and solve things correctly, because once you buy that property, they just don't go away. And they take priority over all other liens primarily out there. But again, this is, as you said, Andy, I think it's understanding the proper navigation of those and being prepared to deal with them appropriately.
Yeah. All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions. So if you have them, post it. Specifically, we're looking for creative finance related questions. We have another one here, guys. If you take a HELOC over, so if you buy the property sub to a HELOC, is it true that they can be locked/unlocked?
Yeah, my experience with them is when we close and we're taking those sub two, is we close them. That line of credit is now closed and cannot be reopened.
Can you imagine what would happen if they didn't do that?
Yeah.
Well, I've seen that happen, and it was a real mess with property was sold and they did not lock it, and the old owner kept drawing down on the line of credit, and that lender also didn't release their deed of trust. So they got a payoff, but that's the thing, right? They got the payoff from title, but it did not contain the instruction to close the line of credit. So the lender kept their lien against the property and then allowed the borrower, who no longer owned the property, to draw down, and drew down like another $100,000 on the line of credit. And then they came and said, oh, well, it's time to foreclose our deed of trust that we never released as part of that escrow. It was a real mess. So yeah, it can be a real problem if you don't close it out properly. It was a mess for title, obviously, because they should.
You may wind up with that, in a fraud scenario against the seller, but good luck with that.
Right.
It's good luck going after the seller who probably blew that $100,000 pretty quick somewhere.
Right. And then it came down to a battle of lien priority at that point, who has still a valid lien against the property, et cetera. So
what is it? Who says, is it Mary Poppins, or who that says an ounce of prevention, or whatever it is? Or is that a spoonful of sugar? I don't know. Whichever one it is.
But that's a fantastic method for borrowing money, though.
Oh yeah.
Yeah. Oh, that's funny.
But what amazes me, guys, is when you talk about liens and whatnot, and I recognize who our marketplace is out there. And, it's not even the 90-10 rule, unfortunately. It's more like the 98-2 rule, where 2% or so become true students of the game. They really want to try, learn, and understand. They'll take the time and come talk to guys like us a little bit in advance, where they will get a good knowledge base of things such as liens and title and whatnot, and understand this. It's that other percentage that doesn't, and all they want to do is they just want to rock and roll through it as fast as possible. Oh, their TC is going to handle everything for them. They need to do nothing. It's all hands off, and things just blow up, kind of like Sean said a little bit, because no one's paying attention to the transaction. The investment community just needs to really stop and become a true student of the industry and the game if you want to be good and proficient at this business.
100%. All right. If you're just joining us, we are taking questions on creative financing. If you're watching us from Facebook or another platform other than YouTube, you'll notice that there's a barcode at the top of the screen. You can scan that. That'll take you to our YouTube channel. Subscribe. That's the best place to follow us for this kind of content. Also, we're taking questions throughout the hour. So give us questions, because if you don't, as much as we like each other, we might just move on and go spend time with our families or eat dinner or whatever.
Hey, can I put my GoFundMe site on here too?
It's just, send me the link. I'll put the barcode up to GoFundMe. Scott?
I keep looking for free money. It just never shows up.
Yeah. We have another question. So let me read this off for you guys. If the buyer stops paying the mortgage on a subto, is foreclosure the only remedy for the seller?
So if the buyer wants to cooperate, a deed in lieu of foreclosure is possible. And then I am seeing instances of these performance deeds, or a deed in lieu signed at time of closing, held in escrow, and to be recorded if you're late 60 days. That's an option. I don't like it because that document's not enforceable as an executory instrument. But those are the only two I know of.
You're still seeing folks wanting to do that?
Yeah, I am.
Yeah, I know we've talked at length. We've talked at length on this show about the problems with that. I know we all agree that there's problems with that. The deed in lieu of foreclosure is an obvious option.
And Andy, I'm just going to comment. If you do a deed in lieu, one thing I see that so many investors, first off, they don't want to call any of us and pay money to have us draft up a deed in lieu form and handle things properly. As I said in the past, investors are just cheap. And I get to say that because I am an investor and I'm cheap. I get it. But at the same token, you know, you got to check title before you do a deed in lieu and make sure there's nothing out there that has attached to the property from your borrower or the seller, for instance, from this investor that's out there. Because if the investor owns the property per se, this is not a homestead. So now anything can attach to that property that's out there against the investor. Mm-hmm. And if the seller, you just don't want to deed the house back to them. I've had investors in the past say, well, I'm just going to deed the house back to the seller. Not a deed in lieu. I'm just going to execute a deed, go record it, and I'm done. I'm going to walk away. And I kind of go, that ain't going to work because the seller's going to have to accept that deed. And you can't just arbitrarily do things like that. But some people think you can. Or again, they don't let the seller search title or advise them, and sellers, they don't go to the trouble of doing that. And they wind up taking the house back, maybe subject to IRS liens or judgment liens and things like that are going to attach to the property now in some format.
Mm-hmm.
Yeah. So, in fact, I had this issue come up yesterday on a property where we were looking at a deed in lieu as an option, but there was a junior lien against the property, and it's, doesn't work because what you're basically saying, Scott, is that through the normal foreclosure process, i.e. notice of trustee sale and proper notices to junior, lien claimants, junior interest holders in the property, you give them notice that, hey, I got a pending sale, and you go through that process. And once you sell the property, it wipes out everything that's below you. But if you do something different than that, such as a deed in lieu, where the property is actually deeded to you, even if the other people have an interest, or entities or lenders have an interest in the property that's generally going to be junior to you, and generally wiped out in the foreclosure, it doesn't work that way with a deed in lieu. You actually go and take title to the property subject to all those other liens, claims, and encumbrances and interests. So if you are a first position lender and there's a second position loan behind you, you can take a deed in lieu, but be prepared to pay off the second and be obligated to pay the second as part of that transaction. So to me, the proper thing to do is go through the foreclosure process, or if you want to do the deed in lieu, like you were saying, Scott, you need to insure the deed in lieu through a title company and get a title report and get title insurance for the deed in lieu transaction. Otherwise, don't do it. Just do a regular trustee sale and wipe everything out below you.
Well, first off, let me just say that 99.999999% of the investor world won't ever do that, although we wish they would in some format. And I got a question. So in Arizona, are you guys required to give notice to junior lien holders? Is the senior lien holder foreclosing required to give notice to junior lien holders?
Andy, you can answer that. You do tons of, not tons, but you are our trustee sale guy. So
yeah, and a trustee sale notices go out.
Do the junior lien holders have the right to cure?
Yes.
Yeah.
Reinstate.
Yeah.
In fact, Alan, you got my email with that statute, right?
I did. I haven't dug through it. That's for me to solve other problems. But yeah, I think it. And then
junior lien holders and successors in interest to the ownership of the property have a right to reinstate. They don't have to be the borrower. And they can reinstate. We have case law that says they can reinstate prior to even the recording or initiation of the foreclosure. They have a right to get those reinstatement figures and reinstate at any time.
Wow.
And my deed in lieu form, initially I'm going to say I'm not drafting up a deed in lieu until you get a title search. And then even if they get the title search, my deed in lieu says they have a right after the conveyance of that property to go and conduct the foreclosure still if some type of lien pops up.
Could you pirate my document?
Do you
Not
think
that-
that does
not
that work
intentional.
in Texas? Does you think that would work? That works in Texas, where if you take a deed in lieu, you can then turn around and enforce your deed of trust?
I've done it once.
Really?
Yeah, but no one was fighting me.
Okay. Interesting.
I believe that
I'm not sure you could in Arizona unless you set it up where the grantee under the deed was different than the trustor under the deed of trust. Because I think under the doctrine of merger, your deed of trust goes away the minute you come on title to the property.
It states it doesn't in the deed in lieu of foreclosure.
Okay.
I don't know if that wins or not, but it hasn't been fought yet.
Let me add Alan right there, and that is provided you haven't released the deed of trust.
But the interests have merged by operation of law. The deed of trust goes away.
I just got through arguing that with an underwriter. I said we don't need a release because it was regarding an MOC by the buyer, and then buyer ended up buying the property and then sold it, and then they said we need a release. And I said, no, that merger clause. And the underwriter said, no, we don't care.
Yeah.
And by the way, as you know, Alan, they always win in those kind of scenarios, right?
It's the golden rule.
It is. So can you become an underwriter so we can make this a little bit easier?
Yeah.
That's funny. All right. If you're just now joining us, this is the Creative Finance Collective. We're talking about all things creative finance related. If you have a question, make sure to post it in the chat. We do have another question. Is providing, hold on, just lost my question here. Okay. Is providing a deed of trust, of
And
promissory note assumption package
And
necessary?
promissory note. Deed of trust and.
Yeah, deed of trust and promissory note assumption package necessary when closing subject tos as security instruments, and if not, why?
Can I go first?
Yeah.
Yes, because we say so. The way we did sub-twos before, it was deeds of secure assumption, no deed of trust, no promissory note, but we're doing them now. And then the why portion is because I want my sub-two transaction looking like a normal transaction, and B, if you go into court and have a deed to secure assumption and nothing else, and that seller's not protected, it looks as if you've overreached and taken advantage of that innocent party as an investor. So you want that seller to have protection so that you don't automatically lose when you roll into a courtroom. Those are my two reasons. And then also, I'm sorry, three, it allows the seller to use that promissory note and evidence of good payment to offset debt to income ratio issues. So the reason I wanted to go first is because I want everyone to start doing it the right way.
And if you live in Austin, guys, there's so much of that funny smoke that comes out around the area that sometimes it permeates into, Alan's office building and those kind of things, I think, from time to time. Just kidding, Alan. So I don't necessarily agree with that. I think provided a buyer and seller have good disclosures in their contracts, and again, if necessary, at the closing table, I think if the seller is protected with a deed of trust where they have a traditional remedy to regain the ownership of their property in the event of a default, which with the right deed of trust, they do. A note, can you incorporate a note? Sure you can. But the reason investors, in my opinion at least, want to do a subject to is to limit liability. It's the whole reason it's there. And Al and I agree, back in the day, prior to like 2000, 9 and 10, we used to do deeds of trust to secure assumption and assumption warranty deeds back then. And then this whole newfangled thing came out that we do today. But I think the key is to ensure that the seller is protected. You know, I'm sure Al and I both have seen some attorneys here in Texas who actually have the seller sign off on a document stating that they're not going to get a deed of trust and their only recourse is to file suit to get the property back in the event of a default, which I think is just abnormal and just flat out wrong. We want to protect our sellers, you know, at every step of the way from that unscrupulous investor or somebody who does not make a payment. And just because they have a note doesn't change that. They can still foreclose. The only issue with the note is they might be able to file a suit to collect under the note in some format. But the question then becomes, are you representing the seller as an attorney to provide this document? Are you representing the buyer not to do so, or just where does that fall in the line? And I don't think it's a right or wrong answer per se. I think it depends on the transaction and what the borrower is asking for as per their contract. And if they put that in their contract, include it in the deal. I'm fine with that. But, you know, not providing security for the seller, I think, is just abjectly wrong for this industry.
So are you saying yes? Are you saying yes for note and deed of trust, or no? I'm not. That some of that wacky weed maybe flew up there to DFW. Yes or no?
No, I'm saying it depends on the deal and what the contract says and what the clients want. If the buyer is willing to do that and provide it to the seller, they've negotiated that, absolutely. If the contract does not provide that, I think you protect the seller with the proper disclosures, with that deed of trust, so they have the easy right to foreclose. You know, the thing that a seller can do, at least here in Texas, Andy and Sean, is you can foreclose on an investor in as little as 21 days, unless your deed of trust says something different. We're not talking a 20-day notice to cure and then 21-day posting. We're talking 21 days. So it can, and I know in Arizona, it's, I think 6 months, right? Is your
no,
90.
It's 90 days for a deed of trust and as low as 30 for like a land contract or agreement for sale. But it sounds like both of you agree that a seller should be given some security, i.e. a deed of trust, so that if the buyer doesn't perform, they can have a remedy, they can foreclose. It's just the question is what that deed of trust is securing. Is it securing a promissory note, or is it securing some other performance agreement? To your point, Scott, I don't know about Texas, but so here in Arizona, I always, if I'm involved in one of these transactions, I always require a promissory note and deed of trust, even if it's just performance only. But I'm not concerned about the liability if it's residential property in Arizona, because we have these things called anti-deficiency statutes, which prohibit a lender, and the seller in this case would be the lender under the performance note, prohibits a lender from ever pursuing a deficiency on a note that was given for the purposes of purchasing the property. So even on a wrap or performance note, the seller has no right, even if there was an amount above the performance, even if the seller was financing, $100,000, they were carrying $100,000, and they were only going to recover, say, 20 grand of that 100, and there's an $80,000 deficiency. Under no circumstances, if it's residential property, can they ever pursue that buyer for the deficiency. So for me, promissory note and deed of trust all day long, because I'm like with Alan, the judges here, if you go and you say, they question, and we've done it. I mean, Brian Locker, my law partner, has gone in and said, hey, judge, this attorney over here is trying to make this seem like some, bizarro, unique transaction. And all it was a wrap. And, the judges understand wraps. I mean, they've been around forever. And so, it's a very, common thing. They don't understand like subto and subject to and all this, new terminology we have. They understand wraps though. And so for me, I like to see the promissory note with the deed of trust that's set up as a wrap. I use the term wrap throughout a lot of my documents because I want it to, if it ever gets in front of a judge, for the judge to look at and say, oh yeah, it was a wrap, okay. And I'm not concerned about any buyer or borrower liability on that because of the fact that we have these anti-deficiency, nor am I worried so much about the seller having liability, because the same works for the lender, who lent the money to the seller to acquire the property. So, we've been gifted with those statutes that were awesome in the downturn as well. We could do some pretty awesome things with those statutes and work some good things out with the lender, because it's like, hey, what are you going to do? Your property's $100,000 underwater. Why don't we work something out here, before you take a big fat loss? So we're lucky here in Arizona with those.
Let me ask one question, make sure I'm conceptualizing things correctly.
Yeah.
And I've got y'all on the witness stand, I guess. So in a subto acquisition, what is the responsibility of the buyer in relation to that underlying mortgage?
To pay it.
They have to pay it.
Yes.
To pay pursuant to the terms of the note.
Why wouldn't we have a note that says you have to pay it?
No, I want to know.
Yeah.
Yeah. I want to know.
Your jurisdiction.
Well, and Scott says in certain situations, but I can't see any situation ever where I wouldn't want to memorialize what the parties are actually intending.
Well, I think the key there is that the deed of trust is to have the borrower perform pursuant to the note that is secured by the deed of trust. So in other words, due on the 1st, typically late in the 15th, and they have to perform pursuant to that note. Now, I will make a comment, at least Alan and everybody else here, that if I was to ever represent a seller in a transaction, which I think may have happened once or twice ever, I would always suggest a wraparound mortgage. Now, we don't have the same things that you guys have got there in Arizona, because we do have deficiencies and those kind of things. But if I had the option to help a seller decide wraparound mortgage or subject to, even if it might be a mirror wrap, I would much prefer to see the wraparound, because it gives the seller more protection from various things. But on the other hand, if it's the investor doesn't want to execute a new note to take on potential liability, because they could get sued under that note for a possible deficiency down the road.
We need to end up on the same page where a note and a deed of trust are required in all sub-twos.
I'm just going to say, read the contracts.
There you go. Oh, well, good debate. So far, that is all the questions we have. I'm scanning.
I'm going to go to Austin, guys, and thumb wrestle with Alan, I guess.
Is that how they do it in Austin? A thumb wrestle?
I do mud wrestling. I don't know.
Oh, mud.
We can be like Musk and Zuckerberg and get some jujitsu going.
Yeah. Didn't Zuckerberg pull out of that thing?
I don't know. I thought it was a joke when I read it the first 10 times or so.
Yeah, they had a whole plan, and Musk. Both of them were working out and preparing. It was going to be a whole match or something. Probably would have taken place in Texas, I'm guessing, because of
Great publicity, right?
Yeah, that would have been awesome. Maybe.
What do they call those big balloon suits that they have now, where you kind of wrap up in this balloon that rolls? You can't really get hurt on anything, and they run in and bounce off each other.
Maybe that's what we're missing for the collective. We need a brawl match. That would get the viewers.
I think the Arizona team is younger than the Texas team.
Oh.
Well, the Texas team might be in better shape. I don't know. Sean's out there sitting in his ice house, ice fishing, I think. I'm not sure.
There's no ice, man. It's like 65 out.
You're in short sleeve shirt, Sean, because it's like 95 degrees in Dallas.
That's funny.
So, Anyway,
Well,
to end this story real quick, Andy, is that I think that the answer for everybody out there is that there are various ways of doing these deals. There's not necessarily a right or wrong. It might be best for what the transaction is, and I think there's going to be little nuances here and there. But I think that at bare minimum, it is always ensure that the seller is protected in these transactions. I like to do it with a deed of trust and a vendor's lien. And, if they want to draw up a note and they have that there, awesome. Let's put it in there and let's go. But once you start drafting more notes, you're almost drafting a wrap that might be a mirror wrap in that scenario versus a subject to. Which, go for it. I got no objection. Just, guys, agree to what it is you want to do and how you want to do it. Have disclosure. Move forward. I'm done with my philosophy.
Right. All right. Well, with that, we don't have any other questions, so I'll let you guys head out. You've been kind with your time. We appreciate it. And looking forward to doing it again next week. Hope to see you guys then.
All right. Thank y'all.
All right.
See you all in a couple of weeks, Andy.